The topic of social media usage with an employee and the wider aspect of their behaviour outside of the workplace is such a hot topic at the moment, and it really snowballed from a few conversations we were having with colleagues, and then with lawyers that we work with, and then bankers that we work with, and HR people that we work with, and suddenly it just completely snowballed. And we ran a similar event in Melbourne, out of our Melbourne office, and the response was phenomenal. So we thought we'd bring it here, and luckily for us, we know Jennifer, Nick, and Rowan really well, and they were happy to come down and share their experiences, and obviously we sent out some invites, and everybody said yes. So it's just a hot topic, I think, and it's a topic that really doesn't have an end at the moment, you know. And it's so anyone with an internet connection that employs one member of staff, you know, you've got it's questions you've got to ask. Absolutely, yes, that would be ideal, because again, it's a global issue of what people should and shouldn't say on social media, and whether it's can have an effect on the employer and the brand that they work for. So it's such a global issue. We will definitely be rolling out. So we've already done one in Melbourne, and actually our Melbourne office has been asked to run another one. So we may well do exactly the same again by popular demand. Next will be from our Johannesburg office. Now, South Africa is such an interesting market from an employment perspective. It's in it's in such a embryonic stage, really, in its employment relations law. You know, since the end of apartheid in 1994, so we're still in the first 25, 30 years of new laws. And this topic is going to be really hot, and we've thrown a few invites out, potential, sort of see if there's any interest, and people are very interested. And then we also have an office in Tokyo, so we would like to do something similar.
I think the big thing is an employer can regulate what an employee does by way of social media or otherwise outside work hours. That's perfectly legitimate. And the reason for that is the employer is allowed to protect its reputation, and the employer is allowed to assess the suitability for the employee to continue in the employment relationship, so the suitability for the job. Now, I think that said, it's important to have in place a policy which applies, and make sure that people are trained in that policy, ensure that it's enforced at all appropriate times, that allows an employer to take into account things that happen outside of work when assessing suitability to continue in employment.
Employers need to do a few things. They need to be very clear with employees as to what their expectations are. This is best conveyed either in the contract, in a policy, in a code of conduct, or something like that. Ideally, it should be written, it should be accessible, it should be updated frequently. Employees should get training on it, because it's no good having something on an intranet or in a drawer somewhere that nobody knows about. And the case law supports this. Employees have to know what the expectation is. In addition to that, it should be very specific. If reputational risk is a key factor for any decision about whether to fire or take disciplinary action, that has to be made clear. So the consequences, you know, which criteria are key, what are the consequences of breaching that? The other, I mean, we're talking about employees, but you also have employees who manage the employer's accounts. So someone in marketing who manages their Twitter account, etc. And there was a case a few years ago with a large clothing retailer in the UK where somebody was tweeting as her colleagues were being dismissed. And the marketing manager was saying, how do we get hold of Twitter? So you need to think about your employees, but also about your bigger picture, your bigger reputation, how to manage that. Don't give the keys to just one person. Make sure that you've got your bases covered.